Major breaking news. The Donald Trump Department of Justice, specifically their Solicitor General's office, has just filed a major brief in the United States Supreme Court dealing with how are we going to deal with so-called non-violent felons and federal gun control law, 18 U.S.C. 922G, in light of the fact that Pam Bondi, the Attorney General, has created a restorations of rights process consistent with federal law. How does all this work together? Well, the Trump administration just told the Supreme Court exactly what they should do, and we're going to break it down when we come back. Hey folks, I'm Mark Smith, host of the Four Boxer Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we have major breaking news here. Donald Trump's Department of Justice has just filed a major legal brief outlining the Trump view of how the U.S. Supreme Court should be dealing with these so-called nonviolent felon cases, and whether or not individuals who have been convicted of nonviolent felons years ago, whether or not they can be permanently disarmed under federal gun control law, 18 U.S.C. 922G1. As you may recall, 922G1 is the statute that's sometimes referred to as the felon in possession statute that says that if you've been convicted of a felony, as defined by the statute, then you are disarmed for the rest of your life. It is a permanent disarmament. Now, as we've explained before on this channel, the game is with the definition of felony for the purposes of this federal statute. There are instances where someone can be convicted, for example, of a state misdemeanor, never spend a day in prison, never have a finding that they're, dangerous to a fly, and yet they can be disarmed for life under the federal statute, because the federal statute defines, among other things, felony to include a conviction of a crime where it was the possibility of going to prison for 2 or more years. So even if there's a possibility under the relevant statute you're convicted of for a misdemeanor under state law that you could have been sentenced to prison for more than 2 years, that constitutes a felony, even if otherwise it's a silly crime. And we saw this in the Brian Range case against Merrick Garland, where Brian Range was convicted like 30 years ago of kind of a sort of small welfare-related fraud, supposedly. No problem, never spent a day in jail, nothing happened other than paying a small fine. And yet, because under that Pennsylvania state statute he was convicted of 30 years ago, because that statute offered up to something like a 4 or 5 years in prison as a possible sentence, even though Brian Range never spent a day in jail, that constituted a felony for the purposes of being disarmed for the rest of your life under 18 U.S.C. 922G1. Well, we have another case before the U.S. Supreme Court, which is somewhat sympathetic facts as well. Melinda Vincent versus Pamela Bondi. This is the Vincent case. Now, Miss Vincent was convicted of essentially a form of bank fraud. She pled guilty to, I think, writing a bad check for a few $100. She also acknowledged in the context of the sentencing hearing that the government had supposed evidence that she had committed more bank fraud and issued more fraudulent checks than that. And of course, there was no evidence of violence or anything like that. So she is now sought, claiming that, look, yeah, bank fraud is no good, but that is not a basis to make me a violent danger and deny me the ability to protect myself and others with guns. You can't permanently disarm me under the Second Amendment. And that was exactly what the question presented here is in this case of Vincent versus Bondi, whether 18 U.S.C. 922G, the federal statute that prohibits a person from possessing a firearm if he has been convicted of a crime punishable by imprisonment for a term exceeding 1 year, that's under the federal statute, complies with whether that complies with the Second Amendment. So Ms. Vincent argues that it does not comply with the Second Amendment because she can only be disarmed if she is a violent danger to herself or to others, and she is undeniably not that, and there's never been any evidence in any respect or finding by anyone that she is such a person, and therefore she should not be disarmed under the Second Amendment. So that gives rise to today's filing by the Department of Justice of Donald Trump, and I think it's a very clever filing here, and although maybe I would have written parts of this brief slightly differently, I think overall I agree with the gist of the Department of Justice here. And the reason why I say that is this Supreme Court, and here's kind of the harsh reality. Remember, you turn into the Four Boxer Diner for sort of the harsh reality of our situation sometimes. This Supreme Court as currently constituted, does like the Second Amendment, does respect the Second Amendment, but this court also does not like criminals. If you look at, for example, the death penalty docket, they're not that sympathetic to people on death row, for example. They're pretty deferent. They defer quite a bit to, state prosecutions and proof that people are found guilty of things. So they're not sympathetic to people that have been convicted of crimes. So in light of that, this brief by the Trump Department of Justice is really very clever, because the Solicitor General's Office of the Department of Justice, as I've explained to you before, under John Sauer, is very savvy and sophisticated when it comes to Supreme Court practice. In fact, that is the job of the Solicitor General's Office, sometimes referred to as the SG's office. When it comes to Supreme Court litigation, this is the office that handles all the federal cases and all the Donald Trump positions in front of the Supreme Court itself. So they are well aware that this current Supreme Court does not like criminals. They're also aware that they like the Second Amendment. So how are they going to balance this? And what the Trump administration did here is very smart and clever, and I think will win strategically. What they've argued here is that, look, we understand that the Second Amendment can be implicated by a permanent disarmament of someone who's been convicted of a crime, someone like Miss Vincent. And we understand that if someone is not a danger to themselves and to others, well, there's a very good chance they can't be disarmed for life. We get that. However, and this is the key sort of I don't call it a sleight of hand here, but the key kind of maneuver or strategy deployed by the DOJ here. And that is, they said, yes, but Supreme Court, you should deny Miss Vincent's request to hear this case, because Miss Vincent has sought cert. She petitioned the court for cert because the lower courts refused to give her relief and find that she had a right to keep in arms because of her conviction. So the DOJ here is saying, look, Supreme Court, she may very well have a very strong argument to get her Second Amendment rights back. In fact, the DOJ basically admits that she has a strong case to get her right to keep and bear arms back, which indicates basically she will. However, what the SG said here is this. They said, look, but the reality is she should apply under the relevant federal statute that Pam Bondi, as the Attorney General, has now set up that allows for the restoration of Second Amendment rights. Remember this, we've talked about this on previously on this channel, where Pam Bondi, as the Attorney General, and her team has moved away from the ATF the authority to restore the rights of people who've lost their Second Amendment rights through committing crimes or being convicted of crimes. She has now put it into her own Attorney General office away from the ATF. She's also now set up a process whereby people can apply to have their Second Amendment rights restored, including, but not limited to, Miss Vincent here. So what the Department of Justice is doing is they're saying, Supreme Court, look, deny cert in this case of Melinda Vincent versus Pam Bondi, because the Supreme Court doesn't need to get involved. Why? Because this case is likely going to become moot, because once Miss Vincent, if she applies for the restoration of her right to keep and bear arms through the administrative process with Pam Bondi's AG's office, she's probably going to get her rights back. So there's no need for the U.S. Supreme Court this term to take up oxygen in the room of one of the 70 cases that the court's likely going to hear this year and spend time on this particular case, because it's not needed, because Miss Vincent's Second Amendment rights are likely going to be vindicated by the Attorney General Pam Bondi, and it makes more sense to do it that way through the DOJ administrative process that has not now been brought back by the pro-Second Amendment Pam Bondi. I know some people don't like Pam Bondi for things she said or did in Florida, but again, Ronald Reagan raised taxes as the governor of California. People can make mistakes and recover from them. And I think that Attorney General Pam Bondi has done a great job on the Second Amendment since becoming the U.S. Attorney General. And that's all that matters for the moment. You know, we've all made mistakes in the past. We can be forgiven if we move forward in the right direction. There's no doubt that the Attorney General's office and the DOJ under Pam Bondi is moving forward in a very, very, very strongly pro-Second Amendment posture and viewpoint, and we should be embracing that and encouraging that. And that's exactly basically what this brief says by the Trump administration to the Supreme Court. Don't grant cert in this case, guys, because you don't need to, because she's likely going to get her rights back. So why do I say I think there's a good chance for Miss Vincent to be able to get her rights back through the administrative DOJ process of restoring rights, and why people should be applying to them to do so? Here's what the Trump administration wrote in their brief opposing the petition for cert in this Vincent case. Petitioner Vincent states that she has waited long enough to regain her Second Amendment rights, but plaintiffs in several other civil suits challenging Section 922G1 have already filed Section 925C applications with the Department of Justice, and the Department of Justice currently is considering their applications. Petitioner Vincent could follow the same course. The Department of Justice cannot prejudge the outcome before it has received her application and investigated the facts, but her petition for a writ of cert suggests, listen carefully folks, for a writ of cert suggests that she would have a strong case for relief. Folks, that's obviously a very big hint that the Department of Justice wants this case to go away. And I think they want this case to go away is because they don't have enough confidence that the current Supreme Court, because they don't like criminals, is going to do the right thing and vindicate the right to keep and bear arms. And I think it's one of these sort of strategic calls is, well, it's going to be a close call. Do we want to push criminals and the Second Amendment to the Supreme Court, or are we better off pushing, let's say, young adults and the Second Amendment to the Supreme Court, which is much more sympathetic to this court to continue to build on strong Second Amendment precedent? Because the last thing we want is bad Second Amendment precedent being set where we lose cases at the Supreme Court. That's the worst possible outcome, because the more Second Amendment cases we lose at the Supreme Court, the more the anti-gunners can use that against us in courts all across America. In contrast, the more cases we win at the Supreme Court level, the better it is for the Second Amendment. And I think there's probably concern by John Sauer, the Solicitor General, and at the Department of Justice that there's no guarantee that the Department of Justice, or I should say that the Supreme Court itself, will be sympathetic to Miss Vincent because she is a convicted criminal. Yes, it's a nonviolent crime, but still, why run the risk if you can solve the problem of Miss Vincent's Second Amendment rights through the administrative process of having her apply and giving her Second Amendment rights back under the relevant federal statute that Pam Bondi, as the Attorney General, is now administering, that statute, which is 925C, that is being brought back by the Trump administration, but has laid dormant since 1992 because of games played by anti-gun administrations, both Republicans and Democrats, but that is not being, that is not dormant anymore. And I think we're going to see thousands and thousands of people, maybe even tens of thousands of people that currently have been permanently disbarred under federal statutory law that may very well have their rights restored under 925C and the Attorney General Pam Bondi's process that she's put in place at the Department of Justice. And just to remind all of you by background, even though we've covered this in prior videos, the game that got played was that Congress denied appropriations to the ATF to restore people's rights. At the same time, prior attorney generals had delegated the authority to just the ATF to restore rights. You see how that game got played? So the AG, not Pam Bondi, but the other attorney generals delegated the authority to the ATF to restore rights. At the same time, Congress since 1992 said in their appropriations bills that no money appropriated by Congress to the ATF can be spent to restore the Second Amendment rights, because Republicans on Capitol Hill did not like criminals, and the Democrats on Capitol Hill did not like guns, so they reached an agreement to deny these people their Second Amendment rights. And that is exactly what, frankly, the Trump Department of Justice had to say about how this all came about. Before 2025, the statutory authority to restore rights had been delegated to the BATF. Since 1992, however, appropriation statutes have included provisos prohibiting ATF from using appropriated funds to act on Section 925C applications. In combination, the delegation and the appropriations bar effectively suspended the Section 925C Relief from Disabilities program. Recognizing that the appropriations bar applies only to the ATF, Attorney General Pam Bondi recently issued an interim final order withdrawing the delegation of authority to ATF to administer Section 925C. And that was fantastic news, which we covered a few months ago. a very powerful move in support of the Second Amendment. And then what's just happened is the Trump administration just told the Supreme Court, in light of the fact that Miss Vincent will be able probably to get relief from just applying for relief from the Department of Justice, you don't need to waste the time of the Supreme Court because she's going to get to the outcome she wants, i.e. her Second Amendment rights will likely be restored, and it will be done in a more efficient administrative way than sucking up time of the U.S. Supreme Court, which has other important cases, including other Second Amendment areas that we need clarified to deal with. And that's basically what this brief says. So to wrap up, I think this is a good strategic move by the Trump Department of Justice. I think they're trying to avoid a 922G1 case before the Supreme Court because they're not confident of the outcome of the case. So they're going to resolve this and moot out these cases through the administrative process of 925C. I think that the DOJ looked down the chessboard, and that is why they're doing what they're doing here, which I think makes strategic sense because we don't want bad precedent set against the Second Amendment. And I think that is clearly a fear as I read this brief that the Trump administration is concerned with, that they could lose this case at the Supreme Court, and that would set back the Second Amendment right to keep and bear arms. But again, take a look at the brief down below. Tell me if you agree, think if I got the strategy wrong. All right, folks, there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at Four Boxes Diner. Don't forget to subscribe both to YouTube and Rumble, and I look forward to talking to you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.